Good day, ma'am. I am Orlando Jr. G. Banikid from BS Criminology 3rd year, Block 2. Presidential Decree number 968, series of 1976, signed on July 24, 1976. At the Malacanang, Manila Presidential Decree number 968, establishing a probation system, appropriating funds, therefore, and for other purposes. Whereas, one of the major goals of the government is to establish a more enlightened and humane correctional system that will promote the reformation of offenders and thereby reduce the incidence of recidivism. Whereas, the confinement of all offenders, prisons, and other institutions with rehabilitation programs constitutes an onerous drain on the financial resources of the country. And whereas there is a need to provide a less costly alternative to the imprisonment of offenders who are likely to respond to individualized, community-based treatment programs. Now, therefore, I, Ferdinand E. Marcos, President of the Philippines, by virtue of powers vested in me by the Constitution, do hereby order and decree the following. Section 1. The title and scope of the decree. This decree shall be known as the Probation Law of 1976. It shall apply to all offenders except those entitled to the benefits under the provisions of Presidential Decree numbered 603 and similar laws. Section 2. Purpose. This decree shall be interpreted so as to a. Promote the correction and rehabilitation of an offender by providing him with individualized treatment. B. Provide an opportunity for the reformation of a penitent offender, which might be less probable if he were to serve a prison sentence. And C. Prevent the commission of offenses. Section 3. Meaning of terms. As used in this decree, the following shall, unless the context otherwise requires, be construed. Thus, A. Probation is a disposition under which a defendant, after conviction and sentence, is released subject to condition imposed by the court and to the supervision of a probation officer. B. Probationer means a person placed on probation. C. Probation officer means one who investigates for the court of referral for probation or supervises a probationer, or both. Section 4. Grant of probation. Subject to the provisions of this decree, the court may, after it shall have convicted and sentenced a defendant, and upon application at any time of said defendant, suspend the execution of said sentence and place the defendant on probation for such period and upon such terms and conditions as it may deem best. Probation may be granted whether the sentence imposes a term of imprisonment or a fine only. And an application for the probation shall be filed with the trial court with notice to the appellate court if an appeal has been taken from the sentence of conviction. The filing of the application shall be deemed a waiver of the right to appeal or the automatic withdrawal of a pending appeal. An order granting or denying probation shall not be appealable. Section 5. Post-sentence investigation. No person shall be placed on probation except upon prior investigation by the probation officer and the determination by the court that the ends of the justice and the best interest of the public as well as that of the defendant will be served thereby. Section 6. Form of investigation report. The investigation report to be submitted by the probation officer under Section 5 hereof shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. Section 7. Period for submission of investigation report. The probation officer shall submit the court the investigation report on the defendant not later than 60 days from receipt of the order of said court to conduct the investigation. The court shall resolve the petition for probation not later than 5 days after receipt of said report. Pending submission of the investigation report and the resolution of the petition, the defendant may be allowed on temporary liberty under his bail filed in the criminal case, provided that in case where no bail was filed or that defendant is incapable of filing one, the court may allow the release of the defendant or recognize the custody of a responsible member of the community who shall guarantee his appearance whenever required by the court. Section 8. Criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. Probation shall be denied in the court if the court finds that a. The offender is in need of correctional treatment that can be provided most effectively by his commitment to an institution, or b. There is under risk that during the period of probation, the offender will commit another crime, or c. Probation will be depreciate the seriousness of the offense committed. Section 9. Disqualified offenders. The benefits of this decree shall not be extended to those a. Sentenced to serve a maximum term. Thank you. Thank you po.